Hello and welcome to the special edition of Focus on Liberia. My name is Dennis Jar and we are broadcasting right here from Atlanta, Georgia. Focus on Liberia is a weekly broadcast on everything Liberian. Quite recently, the Supreme Court has announced in the case of elections in Liberia, and the two things we were expecting were either runoff or rerun. The Supreme Court has denied the complaint of the Liberty Party and UP alleging massive fraud in the October 10th elections. And as a result, Supreme Court has told the NEC to move forward with the runoff elections between Senator George Weah and Vice President Joseph Newman Wakai. The Supreme Court decision has been greeted with mixed feelings in most quarters. The Liberty Party has announced her disappointment with the rulings, but said that the case was tested in court and so the elections can move ahead. The Unity Party expressed similar concerns about the rulings, but is pleased and is ready now to move forward with elections. So we are waiting for the National Elections Commission to announce the date for runoff. The Supreme Court has already also said that there should be some house cleaning, things that should be put in perspective before runoff can take place. The ruling Unity Party has expressed concern that those things may take a longer time to be put in place before runoff can be announced. But in any case, they are ready to move forward with runoff. Some maintain that indeed, rerun should have been the way forward, since the Supreme Court itself has agreed that there were some irregularities and fraud in the elections. Supreme Court said those irregularities and fraud did not amount to the level of calling for an overturn of the results and ordering a rerun. So, all across Liberia, this is the topic that has been discussed. Today, we have called some distinct personalities in studio to discuss the Supreme Court ruling in the face of the Liberian elections. Due to the inclement weather in Georgia today, we are broadcasting remotely. We are not in studio, we are broadcasting remotely. And we are calling on everyone to join us so that we can make this a discussion. We have Judge Melvin Johnson, who's going to break down the Supreme Court decision and what it means. For some of us who have not gone to law school, the 3+ hours hearing got some confused. So we want for Judge Johnson to explain what all this meant, all the things that were discussed on that day. We want someone to break them down for us in simple English.
I think we might have to use the cell phone again like we did last time. I'm hearing you, but very, very low, and I've got my volume up. Can you hear me?
Judge Johnson, is it better?
Judge, we can hear you loud and clear.
Oh, okay. You just came through clearly now. I don't know. Whatever you did, it worked.
Okay. Judge Johnson, can you hear me?
Yeah. Let's step up the volume a little bit.
Okay, let's try this again. Can you hear me?
I can hear you, yes. Let me turn my volume up.
To my audience, so I say, I apologize for the technical difficulties we are experiencing. We are discussing the Supreme Court ruling on the Liberian elections. The Supreme Court has ruled, so I have Dr. Melvin Johnson, Judge. So Judge Johnson, just briefly introduce yourself
Well, first, let me give God praise. I try not to miss doing that. Anytime we get an opportunity to continue to be amongst the living, I think it's a blessing and we should honor God for that. So let me give him praise for the opportunity to be alive and to be on this program. Let me also just say thank you to you, Dennis, as well as the rest of your crew, producers, Stephanie, Patrick, etc. Thank you for the opportunity of being here, and I'm looking forward to deliberating on this very important decision that has been handed down that not only will affect us today, but certainly generations to come.
Okay. So, Judge Johnson, for those I was able to listen in at least 3 hours nonstop to the ruling on Thursday. But for those of us who have not gone to law school, that was a little bit over our head. So, just introduce for us, I know there was a complaint filed by the Liberty Party and the Unity Party that was denied by the Elections Commission, so they took an appeal to the Supreme Court. The Supreme Court denied the complaint and said that the just walk us through what happened at the Supreme Court on Thursday.
Well, first, if I may, you had started to give the procedural posture, the history of the case. I just want to kind of point one thing out with that before I go on to the Supreme Court. The laws of Liberia allow sort of two shots within the National Election Commission. When I say two shots, I mean two chances. So when one files a complaint such as Liberty Party did, there is a hearing officer, kind of like a judge, that is assigned by the Election Commission, and that individual conducts the initial hearing and passes judgment. In this case, that individual passed judgment denying Liberty Party's complaint. Then Liberty Party gets a second chance within the NEC to file and go before the entire board, the NEC Commission Board. That board then reviews the decision of the hearing officer. Again, this person is like a judge, and then that board makes a decision, which they also deny the Liberty Party's petition. They affirm essentially the judge's decision. At that point now, Liberty Party is free to go on to the Supreme Court, which they did. And as you so mentioned, yesterday, the Supreme Court handed down its decision. Now, the decision the Supreme Court handed down, I kind of want to give a caveat because I didn't get a chance to read the decision in its entirety, okay? And so the bits and pieces that I'm able to extrapolate from the phone calls that I received from home, from information that I've got people in Liberia that feed me information regularly, from information they fed me, in addition to that which I was able to extrapolate from the media online. This is what I'm basing my response on. But it appears that the Supreme Court, that Liberty Party had filed alleging basically 4 violations. They were alleging that there was irregularities, and I can go into details in regards to each of these. There were irregularities, there were fraud, there were Liberia statutory laws violation, election laws violation, and then there were also the NEC's in-house rules violation. And so those 4 things were essentially the complaint that Liberty Party filed to the Supreme Court against the National Election Commission. The Supreme Court ruling acknowledged and admitted that all of those 4 violations existed. However, the Supreme Court opined that those violations essentially were not of the level, were not of the scale to warrant a complete rerun, but instead a runoff. So just in a quick summary, that's what the court ruled. If you ask me more, I can give you more detail.
and I think there's a key one there that the fraud it was not massive enough, or they didn't have that weight to warrant a rerun. In your view, what was the weight that the Supreme Court was looking for?
The Supreme Court, in order to have the Supreme Court order a rerun, the court appeared to have been looking for two kinds of magnitude of the fraud, of the irregularities, of the law's violations. So there were two things they were looking for, and they were looking for either or. So Liberty Party did not have to meet both of these, if you would call them magnitude tests. They could have met either or. Test number one was for Liberty Party to prove that the fraud that existed, the irregularities that existed, the laws and rules violation that existed, that those violations were systematic, that those violations were not merely being done on isolated situations at polling station here, polling station there, but that those violations essentially was systematic by the NEC, was global throughout the system. And so whatever proof Liberty Party provided, the court felt that that proof was not enough to show that it was a systematic violation, systematic fraud, irregularities, laws and rules violation. So that's the first magnitude test, if you will, that the court administered and found lacking. The second one was that the court said that if that whatever fraud, irregularities, laws and rule violations that existed, those violations were not sanctioned by the NEC. In other words, they did not appear to have been backed by the NEC. They did not appear to have been encouraged by the NEC. And essentially, the court says that that magnitude test also failed. So the violations upon which Liberty Party filed and was hoping for a rerun, the court felt it wasn't systematic and it wasn't sanctioned by the NEC. And those are common tests that are used by court, not just in Liberia, but frankly, worldwide for cases of this type.
For the sake of our audience watching the show, let's first look at systematic. Okay, in our understanding, whatever is illegal is indeed illegal. Some say what is not done right, I mean, it's not done at all. So if something is wrong, why should a litmus test of being widespread or systematic be the issue? If it is wrong, it's wrong.
First, we have to assume, right, that the court is objective, okay, and we have to assume that we're talking to a somewhat objective mind. It's understandable. Anytime you have a system, even here in these great United States, that system is not going to be perfect. You're going to have individuals working for their own motives or the reasons they have. Those individuals, they will work, there will be irregularities, there will be violations. But the question becomes, do you hold the NEC, the body, the NEC, do you hold them wholly accountable for isolation, for the activity of isolated individual working for the system? Let me put it in this context. Perhaps it makes a little bit more sense this way, this analogy. If you went to Walmart, if you went to a business establishment, a retail establishment, and you walk through the door, an individual that would normally otherwise greet you with pleasantries insulted you, okay? Now, that individual, yeah, they work for Walmart, but if that individual insulted you, unless it can be proven that this is Walmart's policy, Walmart has a system of insulting Black men, or if when employees of Walmart insult Black men, Walmart don't do anything about those employees. Walmart encourages those employees. Walmart support those employees. Unless those things can be proven, the violation of that employee to you would not be held against Walmart Corporation, because the law provides that if that happens in every situation, we would be flooded with cases, and more importantly, that it's just not fair, it's just not right to hold Walmart liable for something that they don't agree with, they don't support, and something that is not part of their system.
Or I'm impacted. So how then can I seek redress? So take for instance, although the elections commissions did not mandate anyone to do it, or things were done without the knowledge of the elections commission, still Liberty Party is alleging that that impacted her vote. So how can you dismiss that? So it could also be that NEC has some vulnerabilities that some unscrupulous individuals took advantage of. So if people did those things, and those things adversely affected candidate A or candidate B has an A and B in the case of Unity Party and Liberty Party, they have the right to be able to seek a rerun to correct those errors. Don't you think so?
You're saying, Brother Job, but under the law and just in fairness as a whole, okay, we have to have different standards for different behavior. We cannot have a situation, just imagine a country, for example, as large as the United States with several hundred million people. If you pass a law that says if one individual working within that system comes forth, conducts a violation, then you have to scrap the whole system. You will never have an election, because you will always have one person willing to take the risk based on whatever incentive that individual has. You are one person willing to do that. And so you just, as I said, if you were to apply that, you would not be able to run a system. If you were to, if the law was to hold, given the corporation example I gave you, if the law was to hold the corporate office responsible for all the actions of all of his employees, whether those actions are part of the system or whether those actions are sanctioned, we wouldn't have corporations, because employees, they misbehave for whatever reason all the time. And so that's not something that was invented by the Liberian Supreme Court, not even Liberia. That's something that just it's systemic. Is stenciled within the law and has been that way for hundreds and hundreds of years.
Okay, that's fair. So let's look at the evidence as was presented by the Liberty Party and the Unity Party. Why was the burden of proof on the complainant? Why was the burden of proof on the Liberty Party or the Unity Party? If at all those things took place, why should it be only the Liberty Party or the Unity Party to prove that?
That's a very good question. Okay, there are two things that the court has to look at. Okay, the court has to look at whether the burden of proof was met, and then the court has to look at the weight with which the burden of proof was met. Okay, so first, let me deal with the burden of proof, and then I'll deal with the weight of it. Depending on the case, whether it's a civil case or a criminal case or quasi-criminal, the law has three different burdens of proof that applies to different types of cases. In this case, the Liberty Party had a burden of proof of what we refer to as a preponderance of the evidence. If you were to try to visualize it numerically, preponderance of the evidence would be evidence that exceeds 50%, basically. So you have to have more evidence that supports your case than less evidence that doesn't support your case. In this case, the court ruled that Liberty Party met that burden of preponderance of the evidence. Now, the next level of scrutiny deals with the weight of the evidence. The weight of the evidence has to relate to the relief that the complainant is filing for. Okay. in this case, when you look at the relief that Liberty Party was filing for, in that Liberty Party says basically the whole system is crap, the whole election was crap, undo everything. Okay. Now, when you seek that level of relief, the standard rightly that goes with that level of relief is that in order for the whole system, for the whole election to be scrapped, then you have to prove that the election, the system systemically had an error, the system systemically had frauds, irregularity, and the system sanctioned those things. And so the court ruled that the burden of proof was met by Liberty Party, but the weight of the evidence as presented by Liberty Party just did not pan out in terms of the level of relief they were seeking. If hypothetically Liberty Party were seeking a lesser relief, I could see a situation where they would have received everything they wanted. But the level of evidence you bring to the table has to comport not only in terms of the burden of proof you're meeting, but it has to comport with the relief you're seeking from the court. And in this case, the burden of proof was met. The court just did not feel that the relief sought fit the magnitude of the evidence presented.
Thank you for that question. You made that clear for those of us who have not gone to law school. But let's look at let's look at the case of for instance, the chairman of the NEC, Mr. Kokoya. Mr. Kokoya, according to the Supreme Court, should have recused himself because he had said something about the ruling about the case even before he could look into it. So because of that, the Supreme Court agreed with the Liberty Party that he should have recused himself. He did not, and then they came down with a ruling, that was not satisfactory to the Liberty Party. Isn't that ground enough to throw out the whole thing that the NEC have done? Because the guy who headed who looked into the case, who headed that commission, should have not been part of it in the first place.
Good question. First, what I will do is I'll answer the question, and then I will speak on some of the issues regarding the chairman, and you're right, some of the things that probably should have been done. Was it enough of a ground, given the fact that the Supreme Court agreed regarding the recusal of the NEC chairman? Okay. Now, here was a problem that led, I think, to the Supreme Court not ruling that by itself was enough ground. The cases can be appealed to the courts in two different ways. Okay. One would be a regular appeal, and the other would be what is called de novo. Okay. A regular standard appeal is where you appeal to the higher court, in this case, a Supreme Court, and you're telling the court that basically some mistakes were made by the person lower that ruled, and you want the court to only look at those mistakes and make a determination whether to overturn the ruling as a whole. Okay, that's a normal generic appeal. There's another kind of appeal that is called de novo. That's Latin for meaning brand new. That's where the appeal comes before the Supreme Court, and the Supreme Court gets to start all over. The Supreme Court gets to essentially disregard the ruling of the lower decision maker, in this case, the NEC, and they get to review all of your complaints in total. Now, in a situation where a recusal is warranted or was warranted, if you're dealing with a regular appeal, because the court in a regular appeal is limited as to what the court can look at and what the court is exposed to, that type of appeal, usually any kind of recusal by the decision maker usually throws out the entire case. okay? But a de novo appeal where the court has essentially the same power, the same scope, the same authority as the NEC did. Even if the NEC decision maker, in this case, Kwakoya, should have recused himself, the fact that the court is not basing its decision on a limited scope, but it has a broad scope of looking at everything brand new, based on that fact, Kwakoya's necessitated recusal would not in and of itself null the entire case, because the Supreme Court gets to review everything brand new. I don't know if that makes sense.
No, that makes sense.
Yeah, so
did it surprise you?
An opportunity to review everything. So even if whatever Kwakoya did, they can speak to that as being a violation, but they're not hindered. They're not relying on anything he did. They got an opportunity to review everything from scratch, so to speak.
That's fair. So Judge Johnson, was this decision expected, or did it surprise you?
First, let me just say that I don't have a dog in the fight. Okay, I'm familiar and I'm acquainted with both sides and have been for some time, but I don't have a dog in the fight. Secondly, I can't honestly really tell you whether it surprised me or not, because as I said before, with the caveat, I wasn't exposed to the evidence, to the information in total that the Supreme Court was exposed to. And so in an effort to be objective and fair and professional, if you're going to Monday morning quarterback another individual, another jurist or a set of jurists, before you do so, make sure that you are exposed to what they were exposed to, because then, you could be speaking unfairly. So I wouldn't say I was surprised either way, but I will tell you that based on everything I've read, this decision does not appear to be out of line. Now, again, everything I've read, I've said before, certainly is not all that has been presented, but it doesn't appear to be out there in left field somewhere. It doesn't appear to be unreasonable.
So, okay, but could it have turned the other way? Is it possible, or that it would have turned into a rerun? What would be the reason if the Supreme Court was to call for a rerun?
Well, I think the systematic issue, the systematic hurdle, if you recall, I mentioned that you've got the burden of proof level, and then you've got the magnitude level that has to comport with the relief you're seeking. So I think the magnitude level, that it's kind of, if there was room for a rerun, I think that's where it could have occurred. But then again, I don't know the systematic fraud, irregularities, laws and rules violation that LP presented. I am aware of some of the fraud irregularities accepted they presented, but whether they presented that in a form and fashion that spoke to a systematic violation, that was the standard that the court used and courts around the world use for this kind of a hearing. That's where, in hindsight, of course, hindsight's always 2020. In hindsight, perhaps that's where LP and his counselors could have focused to make sure that they weren't just presenting. That's where, things could have tipped the other way.
So what precedent does this ruling set for future Liberian elections?
Well, that's a good question. I think it sets a good and a bad precedent. Okay. I think it sets a good precedent because as a people, we can be proud that we had very staunch disagreements, certainly very emotionally driven, financially driven. The stakes are very high. We did not take to violence. We did not take to the street. We, both sides, respected the rule of law. We patiently waited for the rule of law to apply. So I think this sets a very good precedent. And then, as I said, based on the limited information I've been exposed to, analyzing this ruling, it doesn't appear to be unreasonable given their conclusions. Also, too, I watched the interview of the complainants. And they did express dissatisfaction, disagreement with the ruling, but I didn't hear them saying, well, we felt we proved that it was systematic. We felt we proved it was sanctioned by the court. Now, I'm not saying that that's something they require to do during the interview, but I didn't hear that either. So going back to your question, I think it sets a good precedent in that people going forward can feel comfortable. They can have some level of efficacy in the system that if they disagree with an election, they find fraud, they find irregularities, laws and rules violation, they can go to court and expect to be given the same level of due process that these complainants were given. Now, I said that there's a good and a bad precedent that's been set. Number one, as it relates to Chairman Kwakwaya, I didn't read the complaint in total of the LP that was filed. So I don't know if part of their specific prayer to the court. Now, a prayer to the court is basically your specific request, okay? When you go to the court and you type out your complaint and you say, oh, they did this, they did that, they shouldn't have done this, they should have done this. At the end of all of that, you specifically tell the court, I want you to do A, I want you to do B, I want you to do C. I don't know if in that A, B, C, etc., LP, the Liberty Party had listed, we want Kwakwaya recused, or did they merely put, we want to rerun in the specific prayers? Now, usually very seasoned, very trained jurists, for example, if I was representing Liberty Party in this case, certainly that would have been one of my specific prayer. I'm not saying it wasn't, but certainly that would have been one of my specific prayer. Now, what a specific prayer does is it mandates the court to speak to, we are going to grant this request or we are not. And so the bad precedent that I think it sets is that I am firmly of the conviction that Kwakwaya should have been removed, and definitely with this decision should have been removed before the decision that was handed down yesterday, but certainly with the decision should have been removed. Now, where I am at a loss is I don't know if Liberty Party specifically put that as part of their request, because I did not hear the court respond to say, as to your prayer of you want us to recuse Kwakwaya, we are affirming or we're denying that request. I didn't hear them specifically say that. And the bad precedent, one of the bad precedent that's set is that Kwakwaya remains on this case. If I was to advise him or anybody in the government or the NEC, I would certainly urge them to have him come forward, to have him issue an apology for his behavior, issue an apology for his utterances, essentially prejudging the case before he had a chance to judge the case. I would have him come forth also in that presentation to make a good faith attempt to reassure all of the parties that NEC will do its best to be fair and impartial going forward. And then lastly, in that presentation, he will recuse himself from the runoff going forward. I think the fact that he was not removed, number one, and if he and the NEC doesn't take my advice or do basically what I've just said, that it will set a really, really bad precedent going forward, because it will basically say that whenever there's an election or something of this magnitude of such high stakes, if you're appointed chairman, you can basically act a fool. You can express an opinion before you've had a chance to give the complainant due process, and you will still remain on board. You will still get to keep your job. I think that is a horrible precedent to set. The other factor to all of this that I think it's very bad in terms of a precedent to set, the other players that were involved in the violations, in the frauds, in the irregularities, in the laws and the polls. I only heard of one person being arrested. I think a very good precedent to set that I haven't seen would be to drag all of those individuals through the criminal justice system, obviously publicly, so that people can see that violations are not taken seriously. Also, not just so people can see and feel that the past violations have and are being addressed, but also equally important to deter those who perhaps prospectively with the runoff might be inclined to commit the same violations. And so essentially, if they don't see, person A being dragged through the court system publicly, then they might be so inclined to do the same thing because, hey, nothing happened to them. And so in a nutshell, I think it's a good precedent for our people. The way it was handled, it makes all of us and should make all of us very proud for our rule of law, our legal system. But certainly the way of Kwakwaya has been handled so far is very bad precedent, as well as the other perpetrators, the other alleged perpetrators in the fraud, irregularities, laws, and rules violation.
We are discussing the Supreme Court ruling ordering a runoff instead of a rerun. We will focus on Liberia. We want to thank our sponsors. We want to thank Nelson Copper and his group for sponsoring this show. So, Johnson, let's get back into this question. The last time you were on the show, you spoke of some leadership failures that caused the issues we have with the election. Now, as you correctly listed some of the bad precedents in this election, what other recommendations you have for good leadership failures that need to be fixed before we can go for a rerun or for a runoff? I know the Supreme Court clearly talked about what all the NEC needs to do. Who else needs to do something?
I didn't hear the last part. I apologize.
Right. The Supreme Court wants the NEC to do some house cleaning before the runoff. The last time you were on the show, you spoke of some leadership failures, which caused us to be the point where we were with the election. So, and when you looked at those, the precedent that has been set, and you said some of those alleged perpetrators who have been brought to justice. So, on the leadership level, what do you think needs to occur before the runoff can take place?
The question basically, what recommendation would I put forth in terms of leadership that can help with the runoff that's been ordered? As I said already, number one, it relates to the chairman, Kwakwaya. I think his recusal is in order. Also, at the time of his recusal, I think there's some mending of the fences that's necessary. At the end of the day, I think there should be a reminder that he and all of these individuals at the NEC are servants of the people, paid by the people, and they're for the people. And so as a servant, I think the behavior that we've seen, there should be an apology. I think there should be a recusal / resignation, and then some reassurance as to going forward. Now, in terms of the additional things that can be done, I think the NEC has to exhibit leadership that speaks to two areas to the public. One, I would say partiality, and two, I would say transparency. Okay, clearly there were concerns and there are concerns, and the ruling supports the fact that there wasn't sufficient partiality and there wasn't sufficient transparency. And so I think the NEC going forward needs to be very public, very clear about its impartiality and transparency in this case. Now, the court ruled specifically that the FRR, which is the final register roll, the final list, if you will, that the NEC basically exhibit proper leadership and comply with the law as to the publication standard of the FRR. The law requires that all of the parties get a copy of the final list, that the final list is posted at all of the voting places. And of course, that wasn't done before. The court also mandated an order that the NEC clean up, they said, the FRR. And by that, what I believe they were referring to were some of the reports that we saw and I personally tested, where you could go, and I don't know if it still exists, you could go to the NEC's website, put in a particular voter ID number, and it would be assigned to multiple people, or multiple people would have, or one individual would have multiple voter IDs. And so clearly that system was not clean, that it needed to be cleaned up. And then thirdly, the court ordered that the NEC was not to amend the FRR at any point in time. The law of Liberia, in fact, the Constitution of Liberia mandates that if there is going to be any amendment to the final list, that amendment must be done by the court, not by any individual. And some of the violations and irregularities, fraud, etc., spoke to the fact that at numerous polling stations, amendments were being done on that very day. And so those are some of the things that the court ordered that needs to be leadership about. When I mentioned earlier on the show that we didn't have a constitutional crisis, we had a leadership crisis. A leader is supposed, among other things, to lead, to inspire the people, as well as to provide incentives and disincentives. Okay, there just does not appear to be disincentives enough that would deter people from doing some of the things they did. And frankly, I don't have the efficacy, I don't have the confidence going forward that some of the fraud, irregularities, violations we saw will not occur, because as I said, there's been no ramifications for the violations that have occurred already. And so in terms of leadership, that's what a good leadership would do. They would call in the troops, they would huddle up, they would realize the problems they have, they would fix it, they would provide incentives for people to fix it, and certainly they would put out strong disincentives for people who don't comply, so as to discourage, so as to set an example for prior violations, but then equally as important, to discourage potential future violation. So those are some of the leadership steps that hopefully can be taken. Certainly that would be my 2 cents advice to the leadership, that they carry those things out.
All right, that's great. Now, the Supreme Court has ordered certain things to be done before the runoff can go ahead. Who is going to referee those things, and what is going to be the guarantee that they are done? At what point would the NEC go back to the Supreme Court and have a checklist of all the things that they've been completed before the runoff can go ahead, or how is that process going to be monitored?
I apologize, Brother Jai. You would have to repeat yourself. It was, the volume was coming in quite low. The decibel was low. I couldn't hear you.
Okay, so what I'm saying is the Supreme Court has ordered the NEC to do some house cleaning. For instance, the cleaning of the FRR and other things that need to be put into place before the runoff can take place. Who is going to referee those changes, and where will the checklist be presented? Will a checklist be presented to the Supreme Court for the NEC to make sure that they have done all that was required of them before runoff can take place? How is that process guaranteed?
Well, from what I heard from the ruling, right, the Supreme Court did not say, NEC, today is Thursday, go and get the publication standard to comply with the law, go ahead and clean up the FRR, make sure that individuals don't have multiple voter IDs and that a voter ID isn't assigned to multiple individuals. Go ahead and make sure all of these things are clean and come back to us next Friday. They did not order that. And so because they did not order that, or at least I didn't read it or hear it, then it goes to follow that the court, by law, which is normal, it has ordered NEC basically to self-correct. And at whatever point that NEC feels that they have self-corrected and they have made known the self-correction to the public, such as sharing the final role with the two contending parties, publishing the same publicly for the public at large. Whenever NEC has self-corrected, then they can go ahead and have the runoff. And so while that is not unusual for a court to order that, in this situation, given the fact that there has been essentially no consequences, as I mentioned, for Kwakoya, and certainly not sufficient consequences for all the alleged perpetrators, I don't know what good that will do. As I said earlier, I don't have a whole lot of efficacy in the system going forward because I haven't seen and heard sufficient deterrent for the past behavior, certainly deterrent to deter those of prospective future behavior. So I too share that concern. I would have felt more comfortable if the court, for example, would have issued writ of arrests for some of the alleged perpetrators that were mentioned throughout these hearings. I would have felt more comfortable if the court, perhaps sui sponte, that means the court on its own, if the court perhaps sui sponte would have ordered that Kwakoya be relieved of his duty, be recused. Those kinds of things perhaps would have given more comfort to me and the public at large. But honestly, given what has transpired and no consequences, sufficient disincentives for potential violators, I don't know what good, and I'm hoping for the best, but I don't know if human beings will conduct themselves without sufficient disincentives.
Right, and that's my concern as well. Right now, the NEC has been given maybe time indefinite to do this, or is there any guideline that NEC is supposed to follow? I didn't hear if there is any deadline as to when NEC is supposed to conclude all this. So does that mean a free rein for the NEC, or we're just looking at the date of inauguration that has been set? Is that what would be the marker for the NEC to conclude everything?
But in fact, we had a leadership crisis because the Constitution, is a piece of paper. It can prescribe rules and behavior that are expected to be followed. But once you begin to act outside of that, then the Constitution becomes limited. And so essentially, the NEC now, like you said, they don't have a mandated period. The court basically says, do this as soon as humanly possible. And the court is not in a position to order anything definite, because then you got a situation where anything definite in terms of dates, when the rerun should happen and so forth, because then before the court does that, the court would have to evaluate the resources of NEC. The court would have to go into more detail in terms of evaluating the level of the FRR publication that needs to be done to clean it up, the cleaning up that needs to be done, and so forth. But the court is always limited to the complaint that is filed by the complainant. The court usually cannot go beyond that. And so we're in a situation where essentially we're at the call and becking of Chairman Kwakoya and his staff as to them moving with all due deliberate speed as the country, the nation as a whole, as all of us hang in the balance waiting on them. We got in this position because of a leadership crisis. We got in this position because the leadership, in my humble opinion, did not plan properly, did not execute properly, did not put in proper incentives and disincentives to ensure that things get done right, did not put in proper post-evaluative measures to grade things as well as to prepare going forward. And so we continue to be at the call and becking of NEC and Kwakoya, and we just pray and we just hope for the best at this point.
Right. The ruling Unity Party, through its Senate bearer, Mr. Vice President Mr. Bwakai, said this is going to take a long time because, in fact, they want biometrics. So he's predicting that it's going to be a long time before the NEC is ready to conduct the runoff. So if you look in your crystal ball, what are we looking at here? Do we see another elections or the runoff being dragged on to maybe
that's another good question. When the vice president, or in this case, in the capacity of the UP standard bearer, says it's going to take a long time, I'm assuming that he's privy to information that I'm not privy to. Now, without being privy to additional information, certainly if one was to use the process, the time and the process that it took to register the voters, to prepare the FRR, if one was to use that comparatively to what it would take to clean up such a process, to prepare such a process, clearly I tend to agree with him that relatively this will take some time. I don't believe, given that, I don't believe this can be done between now and before the year concludes. In light of the fact that we've got Christmas forthcoming, and the holidays, New Year and so forth, I don't believe it can be done during that time. And so, as I said, NEC, in my opinion now, is charged with showing a level of impartiality and transparency, not just in terms of assuring both parties that they will be impartial and transparent, but also assuring the public at large that as they seek to fulfill the order of the Supreme Court, that they're doing so in an impartial and in a transparent manner, and to do so given the quality of the work that needs to be done, as well as the quantity of the work that needs to be done. I see, given our systems and the lack of best practices, I just don't see that being done between now and the end of the year. Certainly not before the end of the year, and perhaps not even before the president leaves office. And so, again, we remain hopeful and prayerful, but we don't have a whole lot of efficacy given what has transpired, and given, again, the fact that there's been very little disincentives to deter people from doing the same things going forward.
I think we have a caller on the line. Hello? Is there a caller on the line? All right. So Johnson, thank you very much. I think it's been a very fruitful and rewarding discussion so far. At this time, we are about to draw down the curtain. I want to thank you so much for availing yourself. Is there any final thoughts, anything that we've not covered that you want to talk about regarding this ruling?
Good job in terms of bringing forth comprehensive questions to hopefully clear up some things for your viewing and listening audience. I hope it was, helpful to those who were able to view and listen in. I think the takeaway here is that we can be proud as a people that we were able to do something of first impression in our history. We were able to have a very heated dispute politically, very charged, very high stakes, and we comported ourselves with dignity. We waited and carry out the law told us. Granted, as always, with every rule of law decisions, people will be in agreement, people will be disagreement, but I think as a people, not just at home, but certainly in the diaspora as well, I want to say kudos to us. We did very well with complying with the rule of law. Now, on the flip side, I want to say to the NEC that very bad precedents have been set, specifically in regards to Chairman Kwakwaya. I would want to see him come forth, apologize to the nation, given the trust that we placed in him, given what happened. I want to see him not only apologize, but also recuse himself or resign. And then I also want to see the remaining NEC body kind of give the nation some assurance, give both parties and the nation some assurance in regards to them going forward, being impartial, as well as being transparent. And then perhaps most importantly, I want to hear about their actions in regards to disincentives for those who have violated, as well as their plans for any potential prospective violators going forward. I think when those things can happen, It will allay some of the concerns, some of the good concerns, the well-placed concerns that people have, so that we can move forward with a runoff. Now, in terms of time, I certainly hope that NECs move forward with some of the best practices. You know, in a lot of the private conversations I've had with my family and friends, I scratched my head and I wondered why the NEC isn't using some of the more up-to-date systems in terms of the ballots. For example, I think you probably can relate to this. The systems here and in other countries around the world, they're using sort of an old system called a Scantron. That's essentially where you get a piece of paper, you put the marks on it, and the computer is programmed to feed these paper through at a rapid speed and grade it or check it at a rapid speed. The fact that we're not using something like that or something close to that, but we're still manually checking and manually, I think those are not good precedents for us to set. You know, some of the footage is on television of them using flashlight and tubs and all that kind of, excuse my French, foolishness. I certainly don't want to see that going forward. But all in all, we hope for the best. We remain hopeful. I know I personally, being a man of faith, my faith has always been in God to choose a leader for us. And we continue to trust and believe that that will happen. So in closing, Brother John, let me just say thank you to you again. Thank you to Stephanie and Patrick. I'm only mentioning those other two names because those are individuals that I've interacted with. I'm sure you've got others. So the others, please forgive me if I don't mention your name. It's because I've not interacted directly with you. Thank you to all of you. This is a great forum. Thank you to you, Brother John. I think you did an excellent job in being comprehensive with the questions. And most importantly, let me just say thank you to my Lord and Savior, Jesus Christ, for the opportunity to be on this show. Thank you, Brother John. Thank you to your listening and viewing audience. And I trust and hope that all of you will have a great and blessed weekend.
Thank you so much. And on that note, we will be drawing down the curtain. We want to say thank you to all of you. Yes? We're out of time now. Okay. All right. So at this time, we'll be drawing down the curtains. If you have your questions or comments, please post them on Facebook, and we'll have time to respond. On behalf of all of us here at Focus on Liberia, our producer, Yatendi Martin Faye, our studio manager, Mr. Patrick Ansa, our production engineer and guest relations manager, Stephanie Setro. I want to say thank you so much for watching. Thanks to our guest, Josh Johnson, for being here. We also want to thank all of you watching us and those who have been supporting us. Next, so we want to say thank you for all your help. Until next time, this is Dennis Jah on behalf of Focus on Liberia saying, have a great weekend. We will not be coming on this Sunday because we are using this time today to be on the show. So this Sunday we are off. Check us out on Facebook, on YouTube, and also on Twitter.
Vamos, meu amigo, vamos,